Good afternoon, everyone. Welcome to the latest series in our personal financial planning webinar series. My name is Jonathan Moriarty and I'm a committee member of the Cork Chartered Accountants Society. It's my pleasure to introduce you to today's event. Over the course of the last couple of weeks, we've been having a number of sessions covering topics from financial planning to mortgages. Today, I'm delighted to be joined by Sinead McNamara, who's going to talk to us about the legal aspects of financial planning and some things to watch out for. Sinead is a partner in the commercial department of FitzGerald Legal and Advisory in Cork with more than 14 years experience in commercial and insolvency matters. Sinead specialises in advising receivers and Ireland's leading financial institutions on all areas of debt, recovery and insolvency, including their rights and obligations under various charge and loan documentation. Sinead has significant experience in dealing with complex conveyancing transactions, undertaking security reviews and advising both receivers and banks in relation to the sale of repossessed properties. Sinead has a keen interest in employment law and has completed a diploma programme in employment law with the Law Society of Ireland. She's represented clients involved in employment disputes with the employment tribunals and Irish courts. On the 1st of March 2013, Sinead became the Sheriff for Cork County and undertakes this role in conjunction with her role as partner within FitzGerald Legal and Advisory. So welcome, Sinead. Just before I hand it across to Sinead, I might just remind people as well, Sinead has a number of slides prepared which we'll run through. But as we go through the session, there's a Q&A box. So any questions that kind of come to mind, pop it into the Q&A and we'll take those at the end. So Sinead, I might hand it across to you.
No problem, Jonathan. Thanks very much for having me. And you very kindly took 10 years off me in terms of my qualification, but I find it hard to believe, but I'm 24 years at this crack. So thanks for that. So I understand that I'm, late on in the financial planning series of talks that Chartered Accountants Ireland is giving. So I can't promise I have the most riveting of topics because wills and estate planning certainly isn't that, but it is very crucial for people in terms of planning for the future. So what I'm going to try to do is just, give a guide to various considerations that solicitors and accountants need to focus on when they're advising clients in relation to wills and estate planning. I firmly believe that the relationship between solicitors and accountants is vital in terms of properly advising any client, particularly where there's a business involved, because usually people have been working with their accountant for years. The accountant probably knows more about that person and their business, sometimes even than the person themselves. So I find that when I'm doing a will, particularly a complex will for people, engagement with the accountant is vital in terms of, various tax planning and reliefs that might be available, but have to be planned for. And I think in the course of the presentation, I'll be just giving my tuppence worth in terms of various issues that have come up over the years that we need to bear in mind and learn from. So I think before we get on to a will that speaks from death, which is the normal will, we should just refer briefly to what people colloquially call a living will. And what they're talking about there is a document called an enduring power of attorney. So an enduring power of attorney is a document that is executed when a person has full mental capacity. It may never come into effect, but it can come into effect if the person who made the enduring power of attorney loses capacity to make decisions for themselves. So at that point, the person who has been appointed attorney can apply to register the enduring power of attorney. Currently, it's with the Wards Court Office, but that's going to change very soon. And from then on, you'll be registering the power of attorney, the enduring power of attorney, with the Decision Support Service. So what an enduring power of attorney does is it gives the appointed attorney power to deal with the person's affairs who has lost capacity. Now, that can be just, personal issues, but also can be very important in that the attorney will have the power to run a business. So where I'm seeing this coming up in practice is that, people will come into me whose elderly parent has lost mental capacity. So, they can't sell their house. They need urgent nursing home care. There's no way of paying it because the family can't access accounts, can't sell the person's property. So it puts an awful lot of strain on people. So without enduring power of attorney, until the Assisted Decision-Making Capacity Act comes in, it's a ward of court application. So that's a lot of hassle and stress that people don't need in circumstances where all they want to do is make sure that their parent is properly cared for. So I think for accountants and for solicitors, an enduring power of attorney is an important tool to keep in mind and to advise people to give consideration to, aside altogether from the actual will. So just talking about wills generally. So I suppose what people need to bear in mind is if they decide not to make a will, and some people do. So what are called the rules of intestacy then apply. So what happens to your estate in those circumstances is if you have a spouse or civil partner, they take the entire estate. If you have a spouse, civil partner and children, the spouse or civil partner takes 2/3 and the children are entitled to 1/3 shared between them. Now, that can cause problems. I had a situation once where the main asset in the estate was the dwelling house. So the husband died, the family home was in his sole name. So the mother then was in a situation where she was entitled to 2/3 of the house, but her children were entitled to 1/3. Now, she was lucky enough in that her children agreed to claim their share in the estate. But if they hadn't, she would have been in the very difficult situation where she would have been forced to come up with 1/3 of the value of the home. She was an elderly lady herself. There weren't that many assets. So that would have caused severe problems for her. So look, it's important to make a will because aside altogether from who inherits, you have no control of who's going to be your executor, who's going to administer your estate if you don't make a will. There are rules in terms of that as well. So if you want choice in the matter, you need to make a will. So just everyone is familiar with what a will is, but it basically sets out what is to happen after the person's death. So that's important to bear in mind. You'd often hear the term a will speaks from death. So that's what it means. So just in terms of various formalities, now this is more relevant to solicitors and the accountants. So to be valid, a will has to be in writing. It can be written on anything, really. There was a case where a valid will was written on an eggshell, but that was perfectly deemed to be valid. So, to ensure that your wishes post-death are carried out, a will is essential. And again, just to focus, because people get caught up on this, a will only take effect on death. So I would often have people into me saying, look, I've left €10,000 to my niece. So obviously I'll have to put that aside and make sure that's there for her. Not the case. If there isn't €10,000 there, then that's a problem for the niece down the line. So people can get hamstrung in trying to preserve assets that they have covered in the will, but there is no need to do so because the will only takes effect on death. So the property that can be dealt with in a will or property that the deceased or the testator owns either legally or beneficially. Now, it's important to bear in mind that joint property is not covered by a will. So if the family home is in the joint names of a husband and wife, then the husband, in a fit of pique, might decide to leave his share in the house to someone else. If it is owned as joint tenants, that can't happen. So property owned by people as joint tenants on death automatically goes to the other party, regardless of what's contained in the will. So again, just in terms of the advantages of making the will, you have control over what happens to your property on death. It also enables you to look at the different family members you have who you would like to inherit. Often it happens that a particular family member needs special consideration. I've had situations where a child may have mental health issues, may have issues like alcoholism, something that basically makes the testator worried about giving that family member an asset to hold. So in those situations, consideration needs to be given to maybe setting up a will trust whereby, the portion being left to that family member is left to trustees who basically manage it for the benefit of the vulnerable family member. And as we touched on earlier, you know, in a will, you get to choose who handles your affairs on death. So that doesn't happen without a will. But I think in terms of what's most relevant for this series is in drafting your will, and this is a big consideration for a lot of people, they want to ensure that the minimum amount of tax is paid by the people inheriting. You know, I often hear people saying, you know, I've been paying tax all my life, you know, all these assets paid for out of taxed income. The last thing I want is for family members to have to pay tax on what they're getting. So I think, you know, there are various reliefs to be borne in mind when making a will. And as accountants, I think you will be very familiar with most of these. They appear in a later slide, but I think we might just touch on them here. So, you know, dwelling house relief. So that's a very valuable relief if you're leaving a house to one child in particular. So, you know, it has to be prepared for in order to qualify for the dwelling house relief, in that the person inheriting has to have lived in the house for 3 years before the inheritance. So the person inheriting can't own another house and has to remain living in the house for 6 years after the inheritance. If not, there's a clawback event. I think 2 other very useful reliefs, but again, have to be prepared for, particularly in the case of agricultural relief, should be borne in mind by solicitors and accountants. So, you know, as a lot of you know, to qualify for agricultural relief, the person inheriting has to be a farmer. So to qualify as a farmer, 80% of your assets need to be agricultural property. So again, that needs planning for. So there may be a situation that if you have a beneficiary who's going to inherit agricultural property from you, to qualify for agricultural relief, they may need to divest themselves of some of their assets, you know, by way of a transfer to a spouse, so as to ensure that when they inherit from you, that 80% of their property will be agricultural property. So again, they need to farm on a commercial basis for 6 years after inheritance, or else lease to somebody who's going to do that. Both agricultural relief and business relief, very valuable reliefs in that they reduce the value of the asset being inherited by 90%. So, you know, that's a significant relief to lose out on if it's not planned for and prepared for properly. So, you know, in terms of, we've all heard of the Eason's wills, and, you know, a lot of people think that they can do wills themselves. Some of them can, but a lot of them end in disaster. You know, people buy off the shelves wills in Eason's and off they go, and they think they've done a fine will, and it doesn't emerge until post-death that actually the will is invalid because statutory formalities haven't been complied with. So what I'm talking about there is the will needs to be in writing. It needs to be witnessed by 2 independent people who are both present when the testator signs the will and when each witness signs. So that's something to get wrong. A common error as well that people make is they're making their will at home. You know, I decide to leave all my property to my husband, and I have my husband then witness my will. If you witness a will, you can't take any benefit out of the will, so that's a disaster. But I think, you know, legal and financial advisors we've touched on earlier are invaluable in terms of tax planning and ensuring that as little tax is paid as possible. So who can make a will? An adult can make a will, anyone under 18 can't, and to make a will you have to have mental capacity. So we've touched on the witnessing, so we needn't go over this again. So I think for both accountants and solicitors, when advising a client in relation to a will and what's in it, you need to take as many instructions as possible. I've put in there about specific funeral and grave arrangements. That's one to watch, because a lot of clients come into me and they put in details of, you know, their funeral arrangements or their burial arrangements, or the fact that they want to be cremated in the will. Problem is that, you know, after a person's death, the family generally takes some time before they consult with the solicitor. So very pointless then opening the will and saying, oh, Dad wanted to be cremated, and actually now he's buried in the Curragh. So very important for testators to communicate their funeral or burial arrangements to people other than in the will. So I think, you know, there are very specific rights available to spouses, civil partners and cohabitants. So very detailed instructions need to be taken on people's marital or civil status. As well, in relation to children, we'll touch on this later in terms of what reliefs are open to children, but there is a common misconception that people have when they come into me to make a will, in that they think that a child has a legal entitlement to receive under a parent's will. So it comes as a big surprise to them that actually a child is not entitled to inherit. So again, we've touched on joint property. Very important to bear in mind that these pass outside the will. So the reason we're gathering all this information is to spot any tax planning opportunities that may arise, and I think most importantly to allow your client to prepare for them, because, you know, as we've seen in terms of dwelling house relief, in terms of business relief, that there is a bit of preparation to be done to ensure that these reliefs will apply post-death. So actually, before we move on, I think it's important as well to just talk a little bit about the Fair Deal scheme, because again, like tax, a lot of people, they want to avoid, you know, paying the state as much as they can. So for the Fair Deal scheme, or the nursing home support scheme as it's also known as, basically it provides state assistance if nursing home care is needed. Now, to apply for nursing home care, there is a financial assessment that has to be done, and the financial assessment really is to work out how much you are expected to pay towards your nursing home care. So then the HSE will pay the balance of the cost of the care. The assessment will look at assets that you've transferred. So people will come into me, you know, who are quite elderly, and they're telling me that they need to move into a nursing home. So to keep the contribution as low as possible, they're going to transfer, you know, money in a bank account to their children. They're going to transfer the family home at this stage. That won't work, because there is a look back period of 5 years. So if, you know, you want to financially plan so that you pay as little to the state as possible if nursing home care is needed, you know, that planning has to be done at least 5 years before you expect care to be needed. And that's a difficult one to call. So just in terms of the various bequests that can be made under wills, so pecuniary legacies are quite common, and we touched on this earlier. So, you know, common bequest is, I give £10,000, €10,000 to my godson or my niece, whoever. So if there isn't enough money after the payment of all debts to pay the pecuniary legacies, that means that they'll abate. So if you've left, you know, 5 pecuniary legacies of 10,000 each, so that's €50,000. When it comes to it post-death, there's only €30,000 in your bank account, then that's okay. The bequests will be reduced proportionately, so they will be abated basically. So a different type of bequest then is a specific legacy of a particular item. So again, it's not uncommon to see, you know, I give, devise and bequeath my motor car to my godson Mark. Now, I've put up the example there, my E-Class Mercedes motor car. I don't like clauses like that, because the problem is you might decide to trade in, get rid of the Mercedes and own a Jaguar at the date of your death. If you do, your godson Mark, who's expecting to receive your car, gets nothing. So I think it's better to keep things general and just leave your motor car to your godson Mark, because if the motor car is gone, then the bequest is deemed and Mark doesn't get anything. So one of the duties of the executor that you appoint under your will is he has to pay all your just debts, funeral and testamentary expenses. So it's important just to talk to your client in terms of assets that are subject to a mortgage. So if you give a dwelling house to someone and it is subject to a mortgage, then unless the will states otherwise, that person inherits the house and the mortgage on it. Similarly with a car, if there's a car loan or leasing finance outstanding, that will have to be paid by the person inheriting. So if that's not your intention, you have to state very specifically in the will that you're leaving the asset, but that you're directing that the mortgage be paid out of the residue. Otherwise, the person getting the inheritance has to pay any charge owing on it. So to inherit under a will, you have to survive the testator. Otherwise, the gift or the inheritance lapses. So I think, when you're discussing it with the client, it's important to include substitution clauses where possible. So a common one that people like is, they might leave a bequest to their child, but then include a clause that if the child predeceases, that child share is to go to their children. So in other words, it'll go to the grandchildren. It is possible to say that, if your child predeceases you, that child share can go to the spouse. I have found that for whatever reason, testators don't like that. So they tend to ignore the spouse or the civil partner, and they're happy enough with the child's share to go to their grandchildren. So there isn't complete, testamentary freedom when you have a spouse or a civil partner. So unlike the situation with a child, a spouse or a civil partner has a legal share to your estate. So it is not possible to disinherit a spouse. So if you have a spouse and no children, your spouse is automatically entitled to one half of the estate. If you don't leave your spouse one half of the estate, then they're entitled to basically claim their legal right share. So that's similar with a civil partner. Spouse, no children, one half of the estate. If there is a spouse and children, it's 1/3 of the estate. So it's very important to bear in mind, if you are making a will and you're not leaving your spouse what they're entitled to as of legal right, that will only cause problems down the road. So again, in terms of planning, and I had this situation recently, it is possible for a spouse or a civil partner to renounce their legal right share. So the situation I had, it was a foreign couple who were moving to Ireland. Most of their assets were based outside of the jurisdiction. They had bought a substantial property here. Husband had bought it in his sole name, and he came in to me to do a will, and he said he was leaving it all to his children. So I had raised with him, he had a wife, and that could cause problems because the wife was entitled to her legal right share. So there was no point in him leaving the house to his children equally. So he had assured me that his wife had been, properly provided for with the assets outside the jurisdiction. But, notwithstanding that fact, she still had a legal right share in terms of the Irish assets. So she was prepared to renounce her legal right share. So if that is being done, it's very important that the party renouncing gets independent legal advice. So this lady had lawyers outside the jurisdiction. She was happy enough to take advice from them, and she renounced her legal share. Also, in terms of renunciation, I think it's very important that the person renouncing has full visibility on the other party's finances. So the renunciation can be done either before the testator makes the will or at any time after that will is made. So we touched on this earlier in terms of the rights of children. So I won't go through section 117 of the Succession Act. So that's the section of the Succession Act that basically deals with the relief available to a child if they're not left anything, are left an insufficient amount by their parent. So again, just to stress, there are no automatic rights for children to inherit from their parent. If they don't inherit and they feel hard done by, they have an option to bring what's called a Section 117 application. Now, these kind of applications, they're not very common. They can be difficult in that to succeed in a claim, a child has to show basically a need on their part and a failure on the part of their deceased parent to provide for them. So, some people come in, children disgruntled that they felt they didn't get a fair share of their parents' estate. But then when you drill down into it, the parent may have provided for them quite adequately throughout their life by educating them. And when it comes to it, you'd have to advise that, look, there's a fair chance that your Section 117 application won't succeed because, while you were left, less in the will than your siblings, that throughout your life, you were provided welfare by your parent and you were given the opportunity to go and do quite well in life. So, a person in those circumstances, I think, would have an uphill battle in succeeding in a Section 117 application. Qualified cohabitants are also important to bear in mind. So these are people who are not spouses, who are not civil partners, but people who have been living with the deceased. So to be considered a qualified cohabitant, you have to be living with the person for 5 years. If you don't have dependent children, it's only 2 years if there are dependent children. So if a qualified cohabitant has not been provided for under the will of the person they have been living with, it is open to them to make an application to the court for redress or for relief. So the cohabitant, in order to succeed and get relief from the court, they will have to show financial dependence on the deceased. And to succeed, the claim also has to be brought within 2 years. So different factors that the court will consider in deciding A, whether financial relief should be granted, and B, what the amount of that financial relief is. So is the level of financial dependence. They'll also bear in mind the rights of any children of the deceased, duration of the relationship between the cohabitant and the deceased, and also conduct can be brought into play as well. So if a cohabitant comes in and they're asking you sort of to gauge the amount of the relief that they could be awarded, it's difficult because, as I said, there's a myriad of factors that a court will be taken into account in deciding the nature of the relief to be granted. But it's just important to bear in mind when we're advising clients who have somebody living with them, the person making the will needs to be questioned very carefully as to whether that person is financially dependent on them. So if they are, it is very important to advise that if the person making the will decides not to provide for the person they're cohabiting with, that regardless of what they've said in a will in terms of leaving assets to various different people, the cohabitant could very well come back and make an application to the court if they feel that they are financially dependent and could succeed in the action. So just to talk briefly about executors. So executors get their authority from the will. And again, the will only speak from death. Whereas if you don't make a will and an administrator takes out what's called a grant of letters of administration, they only get authority from when the grant of letters of administration issues, whereas the executor derives authority from the will, which speaks from death. So where that's important is an executor can agree a sale of a property before the grant of probate issues, but the sale can't close until the grant of probate issues. Whereas if you don't make a will, the person administering your estate has no such rights. So they basically can't deal with your estate until the grant of letters of administration issues. So we spoke about marriage and civil partnership earlier. So just important to bear in mind that a will is revoked automatically by a marriage or a civil partnership. Now, there is an exception, and that's where the will specifically states that it is made in contemplation of the marriage or the civil partnership. So just an important one to bear in mind, because, you know, sometimes people come in and, you know, they're engaged and they want to, you know, get all their ducks in a row, and they want to make their will. Very important to stipulate that that will is made in contemplation of the intended marriage, otherwise it's voided by that marriage. I suppose, you know, in the world we live in, it's not uncommon now at all for people to have assets in the jurisdiction and outside the jurisdiction. So the first clause at the start of any will that we draft is, you know, this will is made as informed my last will and testament, revoking all former wills. So if you have property outside the jurisdiction, a lot of people would have property in Spain. It's very important in the Irish will, and also if you're changing the will abroad, that the will doesn't revoke the other will which deals with foreign property. So if you're doing a will in Ireland, you know, you would specifically say that it's revoking all former wills dealing with my assets in the Republic of Ireland, so as to ensure that it doesn't revoke the will dealing with the Spanish property, because that's the last thing you want. So the remaining slides basically just deal with the nursing home support scheme, the fair deal scheme that we dealt with earlier, and the various reliefs that I'm sure you as accountants are more familiar with than I am. But just very important to bear these in mind when advising clients in making their will, but most importantly, to prepare for the wills to apply. So I hope that wasn't too fast. Just again, touching on executors, when you're appointing your executor, does the executor have to act? No. So that's why I think it's very important, if you're considering appointing someone executor, that you have a word with them just to make sure that they're willing to act. I think it's really important when you're appointing trustees of minor children, because when you're making a will, you know, appointing trustees and guardians of minor children, you know, you're looking for the perfect person really, because in most cases, trustees and guardians that are appointed are one and the same. So in appointing trustees and guardians, you're looking for people who, you know, will be comfortable in handling money, in investing money, but also who look after your children and who will rear them as you would like to rear them yourselves. So a lot of thought has to go into that. An awful lot of debate often goes in here between clients as to which side of the family the trustees and guardians will come from. But I think, you know, it is very important to have a word with the trustees and guardians and to make sure that they will be happy to act, particularly where there are young children involved. So just if you are appointed as an executor under the will, you can renounce. You don't have to accept the appointment, but just bear in mind, once you have accepted an intermeddle in the estate, as it's called, you cannot then renounce subsequently unless you get leave from the High Court and the High Court consents to you no longer acting. So executors have lots of powers, but the powers under the will, where we draft them, are much wider than the powers that they will be granted by statute. So powers granted under statute can be quite limited. So that's why under a will, we like to give the executors as many powers as possible so that they can, you know, particularly in the case of where there's a business, they can run businesses, that they can acquire assets for various beneficiaries where they see fit. So I think that's the slides, Jonathan. So again, it was probably a bit whistle stop, but there was a fair bit to cover. So I'm not sure if there are any questions, but I'll deal with any that have arisen.
Yeah, no, there's a few. That was brilliant, Sinead. Thanks for that, very informative. So yeah, no, there's a few questions there. I'll try and get through them there. So in relation to where there's an automatic right to inherit in the will, is it always back on the beneficiary to renounce that? What happens in a situation maybe where you've got a breakdown in a relationship? Is there any other way around it, or do you always have to go to the beneficiary?
And relationships, as we all know, break down. So in terms of a judicial separation or divorce, there are usually blocking orders. So you know, if I'm applying for a separation or divorce, part of the reliefs I will be looking for is what's called a blocking order. So blocking orders then will prevent me from claiming a share in the estate of my former spouse. So basically, it abolishes the right of a spouse to claim.
Okay. And for a child, if there was a breakdown in the relationship, is there any way to renounce that, or?
No, because again, unlike a spouse or a civil partner, a child isn't entitled as of legal right to any share of their parents' estate. So I suppose, look, relationships with children, they can break down. And I suppose if that happens, you know, you may have a child who's disgruntled for lots of reasons. And I think in those situations, you'd have to be taking instructions from the client, because if the child is disgruntled, they may be more willing to bring a Section 117 application. So again, if you sort of get that sort of a story from your client, I think it's very important to get the history, you know, to enable the executor to defend a Section 117 application if it's subsequently brought from the child. So again, you know, you would be getting details of any funds advanced to the child over the years, any money spent on educating the child, things like that. So, you know, like everything else, knowledge is power. So the more information you have, the better chance the executor will have to defend any Section 117 claims, because I suppose, you know, unlike other types of actions, in a probate action, the person who has most information is deceased and is no longer there to impart the information. So very important to get the information at the time.
Okay, no, perfect, thanks. Just in relation to a couple who would have bought a house together and it's in both their names, what's the difference between a joint tenancy versus a tenancy in common? And is there a default or?
That's another common one that comes up. So I suppose if people come in here to me to buy a house, you would have the discussion with them as to whether they want to acquire the house as either joint tenants or tenants in common. So Jonathan, if you and I are acquiring a house as joint tenants, on my passing, my share in the house automatically goes to you. So I might, you know, have had a row with you beforehand, you know, before my passing, and I decide, no, Jonathan, I'm leaving my share of the house to charity. Doesn't work, because in a joint tenancy situation, if I haven't made a will, or regardless of what's in the will, my share in the house in a joint tenancy situation will pass to you automatically. So joint tenancy situations are more common, you know, when people are buying properties as their home, or when the people buying the property are in an actual, you know, non-business relationship. Whereas, you know, some people come in then and they're buying a house jointly, but it's a different situation. They're buying the house as an investment. And in those situations, obviously, you know, if you and I decide, look, we've seen a great property, we're going to buy it as an investment and we'll each put in our share. You know, the last thing I will want, no offense to you, Jonathan, is on my passing for you to take my share of that property, because we bought it as an investment. So it will be structured then in the title deed, the property document, that we're holding as tenants in common. So if we're holding as tenants in common, I will be expected to cover my share under the will. So I would leave my share in the property I own with you to whoever I decide. If I don't make a will, then my share in the property I own with you will go onto the rules of intestacy. So after my passing, in a tenants in common situation, Jonathan, you will find yourself owning the property with my beneficiary either under the will or under the intestacy rules. So that's the difference there.
Okay, makes sense. If all the assets are left to a spouse, how does the spouse access a bank account when someone dies?
Yeah, it can be very difficult, and it can leave people in dire straits. Particularly, you know, I suppose traditionally it's happened with wives, where, you know, the husband has dealt with all the finances. There isn't any easy way around it, because generally the banks won't release funds out of a bank account until the grant of probate issues. Now, we're lucky in Cork in that we have a district probate registry. So grants of probate issue faster than in Dublin, in the central registry. But, you know, from the date of death, because, you know, when someone dies, the first period is spent gathering information on the assets. So that can take time. So it's only when you've established all the assets and all the liabilities that you're in a position then to apply for the grant of probate. So when the application goes in, you know, it would be a fast grant of probate if it issued within 8 to 12 weeks. You know, I think that's the least amount of time you could expect. But that could be 6 months from when the person died. So if the spouse then can't access bank accounts, that's a very difficult situation for the person to be in. So I think, you know, when people come in to make wills, it's, you know, it is important to ask whether there are any joint bank accounts. And if there aren't, you would be well advised to tell that person, you know, put enough money into a joint bank account so that at least your spouse can be getting on with things and, you know, won't be in financial distress until the grant of probate issues and the bulk of the assets then can be accessed. Because as we said earlier, joint property, you know, if I have a joint bank account with you, then I can access the funds. Whereas in a party's sole name, it's very hard to access funds, if not impossible, until the grant of probate issues. There is an exception. So the banks generally will release money without the grant of probate to pay the funeral expenses. So what happens there is, you know, the person will send in the bill for the funeral expenses from the funeral home, and sometimes even for the post-funeral reception. So they're then sent into the bank, and the bank then will issue a bank draft paid directly to the funeral home, to the undertakers. So they're really very limited circumstances where the banks will release funds without the grant of probate. So that can cause financial hardship for people if they can't access funds.
Yeah, for sure. Thanks, Sinead. Is there a minimum amount an estate goes into probate? Particularly, maybe someone might have a small amount of assets and might have a will.
Again, generally around the 25,000 mark. You know, if the assets don't exceed 25,000, thereabouts, banks will release without a grant of probate.
Okay. And would the banks have the awareness of the size of the other assets, or is there an element of proof that needs to be done there?
You will have to fill out a status declaration, confirming the amount of assets that are there and certifying that the amount of assets doesn't exceed that amount.
Yeah. Okay. If only one executor is named on the will, and that executor renounces, I suppose, their role after the death of the testator, what happens in that situation? Is there, I don't know, who picks it up, or how does that work?
Exactly. So then you're sort of in a hybrid situation. So it's a partial testacy because there is a will there, but then partial intestacy because our executor who we had has now renounced, so a substitute executor hasn't been appointed. So the person then who will have to step up to administer the deceased estate is spouse is the person firstly entitled. If they're then not, if the spouse is predeceased or they're not able or willing to act, then it's one of the children. So there's an order that you have to go down through to get the person who's entitled to act as administrator. So that's then called, you know, a grant of letters of administration with will annexed. So that person, you know, isn't nominated by the deceased will, but yet they have to carry out the deceased wishes in accordance with the will, because other than the executor, the rest of the will is perfectly fine.
Okay. And is there like a repository or a register of different wills? I suppose the risk of version control, if people come to different solicitors, or if they've used, they have different, are they all, is there a register? Not
pre-death. You know, a will becomes a public document once a grant of probate is issued, and it is possible to get a will then. But no, it is a difficult one. Now, thankfully, and I'm touching wood, you know, I've never administered an estate and have someone crop up with a later will. I mean, that would be a disastrous situation. But I think what solicitors do in practice is, if they are administering an estate, and there would be a suspicion that the person has used various solicitors over the years. We use the Southern Law Association basically to issue a circular asking, is any other solicitor holding a will of, Sinead, McNamara, whoever else. So that's the only sort of safeguard. There isn't an actual register pre-death.
Okay. Have you any experience of prenuptial type arrangements in Ireland? May not be respected under Irish law, but where marriage exists, but are they workable for a cohabiting couple?
Yeah, they are, and their cohabitance agreements are becoming more common in terms of prenups. They're not legally binding on a court, but they can be of persuasive value. So if, to make your prenup as effective as possible, it's very important that there's full financial disclosure. So, if I'm doing one of those, you would fill out, an affidavit of means similar to what you'd be doing in a marriage breakup situation. So you're setting out all the assets you have so that the person who's entering into the prenup with you, disclaiming any interests, knows exactly what they're giving up. So that they're not hoodwinked thinking, oh yeah, I gave up my share, but I never knew he had all that. If I thought he had all that, I wouldn't have given up so easily. So very important to make sure full financial disclosure and that both parties to the prenup get independent legal advice.
Okay. You touched on some of the reliefs there, Sinead, particularly the time-based ones as well. Does the executor have a role there as well? Maybe if you're close to whatever the time period to avail of those reliefs, is that something that can be sort of leaned on a little bit, maybe delaying things a little bit so you do satisfy those reliefs?
No, because to qualify the reliefs, it's the date of death.
Okay.
Is the key. So, you can't sort of say to the executor, oh, look, take your time there in extracting the grant of probate, because that'll bring me up then to, the number of years I needed been living at home with mammy. No, that won't work. So it's date of death, unfortunately. So no role for the executor in that, can't take responsibility.
Okay. Maybe you touched on this already, Sinead, but can a father disinherit his only child and would they have a claim?
Depending on the circumstances, they'd have an entitlement to bring a claim. But no automatic entitlement, there's no guarantee that having brought a claim that the son would have been granted something, because again, there is a misconception that I have to leave my child something. No, you don't. No, most people do. Most people will provide for their children, but there are circumstances where, people will come in, they say, I've been very good to my child all through the years. I bought them a house, I educated them, I want to leave the rest of my assets to charity. It's rare, but it happens. And again, if a child has been provided for, they would have an uphill battle really in getting relief from a court under a Section 117 application. Okay. And can you do a ranking in your will where you're bequeathing a number of requests and maybe the estate has got smaller by the time it comes to distribute it? Would you do ranking, particularly if you're giving out different monetary amounts to different people? Does everything get reduced, or if it does. It does. So I think, if there is a fear, I suppose, that there won't be enough left to pay everyone, sort out the people you absolutely want to be sorted, so give your 10,000 to A, B, C and D, and maybe then put in a catch-all in the residue that everything else is divided between the other people. So, if there's nothing in the residue, they can't take it. But then I suppose equally, if there isn't enough there to give the 10,000s, then as we said earlier, that 10,000 will be reduced proportionately if the funds simply aren't there to pay all the monetary bequests.
Okay. I think that's all the questions we have, Sinead, which was a good few. So obviously you've provoked a lot of interest, and it's certainly an area of interest to people, and maybe probably don't devote enough thought to. And I think the big thing that probably comes through there, it's the planning is probably huge, and probably the conversations with people as well. And it's probably something I guess people probably shy away from.
A lot of people do, because I think they think that, you know, if we're talking about wills, we're sort of, you know, facing up to our own mortality. But, you know, if wills aren't made, it can just leave an absolute mess when the person dies. So, you know, I suppose I'm at this, as we said earlier, for 24 years. So you would be expecting to do a number of wills for clients during that period. So normally when I buy a house for people, they want to make a will, even though in lots of cases they will hold as joint tenants, so the house will flip across anyway on death, but they still want to make a will, and that's fine. You'll next see them when they have children, because then they'll want to provide for, you know, if husband and wife go at the same time, they'll want to provide for who will look after the children after their passing. And then you probably won't see them again until the children are older and maybe have found their own ways through life, and, you know, they might want to benefit one child. They don't like this child's spouse, so they want to make sure they have nothing to do with the estate. And then there might be a child who's vulnerable or who needs specific consideration, like trusts or care, trusts for various reasons. So you would be expecting to make a number of wills for people. And what I would say to people is, you know, fine, you've made the will, put it away in a drawer, but just be cognizant of what you said, because circumstances change. So, you know, if you have young children, you might decide on 2 guardians who at the time seem eminently suitable, but down the line things might happen. You kind of go, oh, actually, no, I wouldn't like those people looking after my children. So it's just very important to keep the contents of a will under consideration and change your will as your own personal circumstances change.
For sure. Okay. Thanks very much, Sinead. And look, that brings us to the end of today's session. And on behalf of the Cork Society, thanks very much, Sinead. As I said, look, that was very informative, and I'm sure lots of people took that away as well. So I think you shared your contact details there at the start, so we can
absolutely. So if any questions arose that I didn't deal with, feel free to give me a call or bang me an email. Okay.
Thanks. And thanks everyone too for joining us here today. Hopefully you found the session insightful and took away a few items for it, a few things to do maybe. As we talked about at the start, this is our third in the personal financial planning webinar series. Next week we've Dermot Good of Total Health Cover, who will look at health insurance, another interesting space. And you will find a link to register if you haven't done so already on Fiona's email, the newsletter. And if you have any other questions or need any suggestions for events going forward, don't be afraid to reach out to Fiona or anyone else on the committee. So I would be delighted to hear from you. So that's it. Thanks again, Sinead, and thanks
very much,
everyone for joining. All right, thanks.